Welcome back everybody to our lessons on the law of contracts. In this video we're continuing to talk about the creation of contracts, focusing specifically on this idea of consideration and focusing on the idea of past consideration. This is sort of going to be part of a broader conversation that we're having in relation to the various different types of consideration. We'll talk about the notion and continuation of the notion of consideration in the law of contracts in this video, and we're going to talk specifically about the idea of past consideration, or at least the rule against past consideration. You could even frame this argument or frame this legal principle as an idea relating to the temporal nature of consideration. There is a certain time element that is attached to an understanding of consideration for the purposes of contracts. What does this mean, therefore? Well, past consideration simply refers to the view that consideration cannot be given once an action has been performed. There is a certain time period that is required for consideration to have existed, and then if that action has been performed, then consideration can't be given once that action has been performed. It can't be past consideration. So let's, for example, think about this. If we were to have an agreement for you to do something for me, and once you have done that, I promise to give you some money in return. You cannot sue me for breach of contract if I fail, because this is an idea known as past consideration, because I gave the consideration only once you have performed the act. Okay, there has to be at least a certain amount of coincidence when it comes to the actions and or obligations that you are going to be exchanging. They have to coincide, at least to an extent, with each other. Okay, so you can't have a promise for someone to do something for me, and then so only if they do that promise, then the consideration exists. There has to also be the agreement that the promise is made to give me some money, and this would be in return for the action to do something. Okay, and so in this case, there would not be a contract. There wouldn't be a contract between me and you in this example because consideration had been passed. It had not been done at the performance of the action in question. So yeah, we generally do not accept the existence of past consideration in English law. Let's look at some cases to illustrate this point. The case of McArdle from 1951 illustrates this point quite nicely. It was a case which involved a son and a wife who had lived in the house of his mother. Okay, so the mother was the mother of the son, and the daughter-in-law of the mother as well, the wife of the son. The wife had made a number of renovations to the property. So she had done a number of different things to the property to renovate it, to make it look a lot nicer, which the mother sought to have compensated. She did so by getting her other children to sign an agreement to pay her when the estate is sold. So the agreement essentially was, you've made these renovations, you've gone to quite a lot of cost and quite a lot of effort to do so. What I will do is I will say that you will be compensated when the estate is sold, okay? And I've got my children to sign an agreement to pay you for this compensation when the estate is sold. The estate was to be sold on the death of the mother. So when I die, this house is going to get sold, and you're going to get compensated for these renovations that you did. When the mother did die, the children then went back on their promise and refused to pay her for the renovations. Not particularly very nice, but when the wife sought to claim for a breach of contract, the claim failed, owing to the fact that the consideration that she had been given was past consideration. She had already performed the renovations, and so therefore, as a result of which, the subsequent pledge to pay her did not make for a legally binding agreement. It didn't make for consideration, okay? She had performed the renovations, and then only after the performance of the renovations, she had done her end of the virtual contract, if you will. The mother then said that they were going to make an obligation to have her be paid after the estate is sold. This is known as past consideration. Therefore, there was no contract, and therefore there could not have been a breach of said contract. Going all the way back to 1615, we have the case here of Lampley and Braithwaite. This case was one that gives us something of an exception to the past consideration rule. The rule that past consideration is not valid. This seems to challenge that perspective, at least in certain circumstances, that past consideration could still constitute validity for the purposes of the creation of a contract. It does so on the basis that if an act is requested, then there is an understanding that it will be rewarded. This constitutes valid consideration even if the performance is past. The case itself involved the defendant who had killed a man and who had sought to get a pardon by asking the claimant if he could obtain it for him. So, 1615, there was a likelihood chance that he would probably go to the death penalty as a result of being a murderer. He had killed a man and he wanted to get a pardon, and he asked the claimant for a pardon. The claimant went about an arduous process, which was costly to himself, but was told that he would be rewarded if he did. This reward never came. The claimant then sued the defendant as a result of this. The efforts that the claimant had gone to were in relation to the promise which was made on the part of the defendant to reward him had he been successful in securing the pardon. And so the result of all of this was that even if the performance was technically past, it was done so on the basis that the act was going to be rewarded. So he had only performed the action of going through the arduous task of trying to get a pardon because he was told, hey, if you do so, I will reward you as a result. So therefore, consideration, even though performance had been past, consideration had not been.